The Senate will come to order, and our scouts will lead us in the pledge.
Please join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. 2.
Please thank them for posting the colors and joining us today and leading us in the pledge.
Thank you.
Mr. Majors, please call the roll.
Senators Aguilar, Baumgartner, Carroll, Cook, Crowder, Donovan, Garcia, Grantham, Guzman, Heath, Hill, Hodge, Holbert, John, Johnston, Jones, Kafalis, Kerr, Lambert, Lundberg, Marble, Martinez-Humanic, Merrifield, Neville,
Excused.
Newell, Roberts, Scheffel, Scott, Sonnenberg,
Excused.
Stedman, Tate, Todd, Ulibarri, Woods. Mr. President,
Here, with 33 present, 0 absent, 2 excused, we have a quorum. Senator Tate.
Thank you, Mr. President. I move that the Journal of Monday, March 7th be dispensed with and it be accepted as amended by the Secretary of the Senate.
We're going to need a modified motion to that. We cannot dispense with the journal. We could dispense with the reading of the journal. Please,
Thank you, Mr.
Senator.
President. May I substitute the word reading into the previous motion?
You may include the word reading.
I move that the reading of the Journal be dispensed with of March 7th. I do know it by heart. You're just complicating it. Say it. Thank you, Mr. President. I move that the reading of the Journal of Monday, March 7th be dispensed with and be accepted as amended by the Secretary of the Senate.
What would your alma maters think about that motion?
They would approve.
You've heard the motion. All those in favor say aye. Aye. Those opposed, no. The ayes have it. The motion is adopted and the journal is approved. Reports of committees of reference.
March 7, 2016, Mr. President, the Committee on Judiciary has had on consideration as a hearing on the following appointments. Recommends the appointments be placed on the consent calendar and confirmed. Members of the State Board of Parole, effective November 23, 2015, for terms expiring July 1, 2016. Alexandra Jennifer Walker, Sedalia, Colorado, serves as a citizen representative and occasioned by the resignation of Brandy Carey Schaefer of Longmont, Colorado, appointed for terms expiring July 1, 2018. John M. Odell of Loveland, Colorado, serves as a law enforcement representative, reappointed. March 7, 2016, Mr. President, the Committee on Judiciary has had on consideration as a hearing on the following appointments. Recommends the appointments be placed on the consent calendar and confirmed. Members of the Colorado Commission on Judicial Discipline, effective July 1, 2015, for terms expiring July 30, 2019. Yolanda Lyons Fund of Monument, Colorado, to serve as a non-attorney, reappointed. Elizabeth Krapa of Evergreen, Colorado, to serve as an attorney, appointed. March 7, 2016, Committee on Judiciary, after consideration, the Mayor's Committee recommends the following. House Bill 1085 be referred to the Committee of the Whole in favor of recommendation, with the recommendation be placed on the consent calendar. March 7, 2016, Committee on Business, Labor, Technology, after consideration, the Mayor's Committee recommends the following. House Bill 1011 be referred to the Committee of the Whole in favor of recommendation, with the recommendation be placed on the consent calendar. March 7, 2016, Committee on Business, Labor, and Technology, after consideration, the Mayor's Committee recommends the following. House Bill 1151 be referred to the Committee of the Whole in favor of recommendation.
Senate Services.
March 8, 2016, correctly engrossed, Senate Bills 85, 126, and 135, Senate Resolution 2, correctly revised, House Bill 1051, 1064, and 1091, correctly re-revised, House Bill 1119.
Introduction of bills.
Senate Bill 151 by Senator Sonnenberg concerning the right of Coloradans to hunt wildlife in connection with establishing hunting as the primary means of managing wildlife.
Senate Bill 151 is assigned to the Committee on Agriculture, Natural Resources, and Energy.
Senate Bill 152 by Senator Aguilar and Representative Lantin concerning notifications of health care billing charges for covered persons.
Senate Bill 152 is assigned to the Committee on State Veterans and Military Affairs. Third reading of bills, consent calendar. Majority Leader Scheffel.
Thank you, Mr. President. I move that the Senate proceed out of order for purposes of consideration of Senate Joint Resolution 13.
You've heard the motion that the Senate proceed out of order for consideration of Senate Joint Resolution 13. All those in favor say aye. Those opposed, no. Hearing no conflict, the Senate will proceed out of order for the consideration of Senate Joint Resolution 13. Mr. Majors, would you please read the title to Senate Joint Resolution 13?
Senate Joint Resolution 13 by Senator Newell and Representative Lee concerning recognition of October as Conflict Resolution Month in Colorado.
Senator Newell.
Thank you, Mr. President. I move Senate Joint Resolution 13 and ask for it to be read at length, please.
Whereas conflict resolution encompasses many forms of responses to differences such as mediation, arbitration, facilitation, collaborative decision-making, ombuds activities, and restorative justice. And whereas these conflict resolution processes empower individuals, families, communities, organizations, and businesses to foster communication and devise solutions that are acceptable and responsive to the needs and interests of all parties involved. And whereas conflict resolution is taught and practiced by citizens in many school systems, universities, and graduate programs throughout Colorado and the world as a way of solving disputes. And whereas community-based conflict resolution programs work to strengthen local relationships by fairly and equitably resolving neighborhood and community conflicts and opening community dialogues based in reason and mutual respect. And whereas professional associations of conflict mediators promote peaceful and creative resolutions to disputes. And whereas the General Assembly, in passing House Joint Resolution 97-1020, demonstrated its support of alternative dispute resolution, ADR, because of the cost and time savings that ADR brings to the handling of disputes by the state court system. And whereas additional benefits produced in appropriate cases through facilitative party-centered mediation include more creative and more durable interest-based resolution, increased satisfaction for the parties who are active participants and ultimate decision-makers in the negotiation, and the preservation of personal relationships, thereby decreasing the likelihood of strained relations among the parties and further disputes. And whereas the Colorado Legislature's reputation for working across party lines to enact sound policy has had a very real impact on economic progress and job creation throughout the state. And whereas Governor John Hickenlooper has proclaimed the month of October to be Conflict Resolution Month in the state of Colorado. Now therefore be it resolved by the Senate of the 70th General Assembly of the state of Colorado, the House of Representatives concurring herein, that we, the members of the Colorado General Assembly, join the governor in recognizing October 2016 as Conflict Resolution Month in the state, that we invite Coloradans to create events and celebrate and promote the use of productive conflict resolution in their communities, that we call upon leaders across the state to use Conflict Resolution Month as an occasion to discuss the principles and use the practices of conflict resolution in their homes, schools, neighborhoods, congregations, and workplaces, and that we encourage every citizen in the state to reflect upon the conflicts present in his or her own life and to work responsibly to peacefully resolve those conflicts. Be it further resolved that in conjunction with Conflict Resolution Month in Colorado, October 2016, the General Assembly encourages development of educational and training programs that emphasize the special benefits of facilitative, interest-based, party-centered, and restorative mediation, and that bring these special benefits to the attention of judges and other officials and staff in the state court system, state executive branch, and local governments throughout the state. Be it further resolved that the General Assembly encourages the participation of judges and other officials and staff in the state judicial branch, state executive branch, and local governments in projects and programs celebrating and observing Conflict Resolution Month of 2016, and like House Joint Resolution 97-1020, that copies of this joint resolution be sent to the Chief Justice of the Colorado Supreme Court, the State Court Administrator, the Chief Judge of each judicial district in the state, and the Court Administrator of each judicial district in the state. Be it further resolved that copies of this joint resolution also be sent to Governor John Hickenlooper, Patrick Flaherty, Executive Director of the Colorado Bar Association, Perry McMillan, Chair of the Colorado Restorative Justice Coordinating Council, Gregory L. Moore, Editor of the Denver Post, Sarah Johnson, President of the Mediation Association of Colorado, Holly Panetta, Director, Office of Dispute Resolution in the Colorado Judicial Department, Brian Price, President and Board of Directors of the Conflict Center, Beth Cronister and Dilpreet Jamu, Co-Presidents, Board of Directors of the Interfaith Alliance of Colorado, and each member of Colorado's congressional delegation.
Colleagues, please be seated. Senator Newell.
Thank you, Mr. President. And thank you, members, for allowing a few moments of hearing about the benefits of the conflict resolution professionals that we have in the state of Colorado, the benefits that we've seen over the years. As most of you know by now, this is my 8th year in doing the Conflict Resolution Month resolution. And in that, it is, of course, being termed out. It is my final year to do that, so I am hoping that someone will take up this baton after I am gone and speak for just a few minutes in a civil chamber, in a civil manner, how important conflict resolution is to Coloradans. So why are we talking about it now if it's in October? Well, we don't have session during October, so that is one reason. But the other reason is to allow you and Coloradans to prepare for the month of October, and particularly this October is probably going to be, if the debates have been any example, we are going to have huge incivility, and we need to be those voices of calm in the month of October to help our constituents, to help our family, to help our neighbors, to help our business owners, to make sure that they are practicing their skills or learning new skills about conflict resolution. And how do you resolve disputes in a peaceful, civil way where it can be beneficial to all parties? So with Colorado, we have been doing this now for 8 years. We were the first state in the country to, instead of having a conflict resolution day, to have a whole month dedicated to conflict resolution. And that is because we realized there was too much activity that needed to happen for us to do it all in one day. So joining me today are the some of the conflict resolution and alternative dispute resolution professionals whom I'm hoping you will use in your own communities. We have volunteer and professional mediators, restorative justice practitioners, facilitators, deep dialogue facilitators, those people who can come into a room and make sure that not only are we resolving or managing the conflict, but we're working on preserving the relationships. And that's the difference between, sometimes you will hear, well, I solved that conflict. Well, did you, if you're not talking to your neighbor anymore? You might have resolved it temporarily, but did you save that and preserve that wholeness of that relationship? And so I entreat you to join me this year in going out in your own communities and looking for those professionals who are in during the month of October. And then you can also have speakers come to your town halls and actually teach. We've done this in some of our town halls. We've taught literally our constituents on how to resolve conflict and do a little mini lesson on conflict management. So I entreat you to do that as well, and recognize that we also in this chamber are mostly very civil, and we're fortunate that we have a government that allows for open dialogue where we can disagree vehemently, but we can do so in a civil way. So I thank you for allowing us to take a few moments just to remember that there are constructive and peaceful ways to resolve conflict.
Senator Todd.
Thank you, Mr. President. Good morning, colleagues. I rise in support of Senate Joint Resolution 16013 for the 8th year in a row. 4 of those years were when I was in the House, and now 4 years here in the Senate. When we think about some of the issues that we hear from our business community particularly, they talk about some of the biggest struggles and biggest strife is people being able to resolve conflict, being able to come together and figure out what is the mission and role of their business, what is the mission and role of the project they're working on, and to be able to bring people together. Sometimes we call those soft skills, sometimes we call them survival. As a former teacher, helping our students know and understand how important it is to really look at what the issue is as opposed to who the person is that you're in conflict with, and being able to bring that together and have reasonable conversations and be able to have good resolution. And sometimes it takes a mediator, sometimes it can be with 2 different people working on it together. This is not to take anything away from our friends that are attorneys and that things escalating and go to court, but it is a way of being able to problem solve along the way. I do want to give accolades to the senator from Littleton for her dedication and her hard work on conflict resolution. She has carried the torch nobly for somehow of a resolution. So again, this is a skill that we can use with our children, we can use it with our spouses, we can use it in our workplace, we obviously can use it down here, but even in any of our community endeavors. And so I challenge us to remember in October the things that we're talking about today here in March. Thank you very much, Mr. President, and thank you to my friend from Littleton.
Is there further discussion? Seeing none, the motion before the body is the adoption of Senate Joint Resolution 13. Are there any no votes? With 33 ayes, 0 no, 0 absent, 2 excused, Senate Joint Resolution 13 is adopted. Co-sponsors. Senator Newell.
Thank you, Mr. President. I ask for the present roll call to be added as co-sponsors and join us in being the most civil state in the Union.
There is objection. Co-sponsors. Senator Merrifield, Mr. Majority Leader. Senator Martinez-Humenick. Senator Carroll. Senator Heath. Senator Tate. Senator Crowder. Senator Woods, Senator Kerr, Senator John, Senator Stedman, Senator Donovan, Senator Scott, Senator Roberts, Senator Cook, Minority Leader Guzman, Senator Kafalis, Senator Hodge, Senator Holbert, Senator Lundberg, Senator Ulibarri, Senator Aguilar, Senator Garcia, Senator Todd. Senator Jones. Senator Johnston. Third reading of bills, final passage, consent calendar. Mr. Majors, would you please read the title of all the bills on the third reading of bills, consent calendar?
House Bill 1051 by Representative Van Winkle and Senator Holberg concerning the issuance of beneficiary designation forms to facilitate the transfer of ownership of a vehicle upon the death of an owner. Senate Bill 85 by Senator Stedman and Representative Willett concerning the Colorado Uniform Trust Decanting Act. Senate Bill 126 by Senator Roberts and Representatives Garnett and Nordberg concerning parity of state chartered banks with federally chartered banks regarding frequency of meetings. House Bill 1064 by Representative Brown and Senator Roberts concerning local licensing of medical marijuana testing facilities. Senate Bill 135 by Senator Aguilar and Representative Janal concerning pharmacist provision of healthcare services that have been delegated by another healthcare provider. House Bill 1081 by Representatives Thurlow and Mitch Bush and Senator Sonnenberg concerning a change to the biennial filing date for rate-regulated electric utilities to submit their plans for transmission facilities to the Public Utilities Commission, and in connection therewith deleting the requirement that the Commission issue a final order within 180 days after an application for the construction of expansion of transmission facilities is filed.
Majority Leader Scheffel.
Thank you, Mr. President. I move that the Senate adopt the bills listed on the third reading of bills for final passage consent calendar, which includes House Bill 1051, Senate Bill 85, Senate Bill 126, House Bill 1064, Senate Bill 135, and House Bill 1091.
You have heard the motion. Is there further discussion on any of the bills on the third reading of bills consent calendar? Are there any no votes on any of the bills? With 33 ayes, 0 no, 0 absent, 2 excused, House Bill 1051 is adopted. Co-sponsors: Senator Heath, Senator Woods, Senator Baumgardner, Mr. Majority Leader, Senator Roberts, Senator Jones, Senator John, Senator Tate, Senator Lundberg, Senator Hodge, Senator Stedman, Senator Crowder, Senator Grantham, Senator Todd, Senator Merrifield, Senator Scott, Senator Marble, nope. Senator, scratch that, Senator Martinez-Humenick, Senator Marble, I called you as a co-sponsor. Did you want to be a co-sponsor? Okay. With 33 ayes, 0 no, 0 absent, 2 excused, Senate Bill 85 is adopted. Co-sponsors: please have the President. Too late. Senator Roberts, Senator Lambert, Senator Crowder, Senator Heath, Senator Martinez-Humenick. It's a co-sponsors, not a support group. Senator Kerr. With 33 ayes, 0 no, 0 absent, 2 excused, Senate Bill 126 is adopted. Co-sponsors: Senator Baumgardner, Mr. Majority Leader, Senator Heath, Senator Tate, Senator Cook, Senator Woods, Senator Lundberg. With 33 ayes, 0 noes, 0 absent, 2 excused, House Bill 1064 is adopted. Co-sponsors: Senator Stedman, Senator Holbert, Senator Scott, Senator Heath, Senator Kerr, Senator John, Senator Johnston, with 33 ayes, 0 no, 0 absent, 2 excused, Senate Bill 135 is adopted. Co-sponsors: Senator Crowder, Senator Stedman, Senator Newell, Senator Carroll, Senator John, Senator Kafalis, Senator Todd, Senator Roberts, Senator Merrifield, Senator Heath, with 33 ayes, 0 no, 0 absent, 2 excused, House Bill 1091 is adopted. Co-sponsors: Senator Jones, Senator Cook, Senator Scott, General orders. Second reading of bills, consent calendar. Senator Holbert.
Thank you, Mr. President. I ask to be listed as a co-sponsor on Senate Bill 126.
Senator Holbert will be listed as a co-sponsor of Senate Bill 126. Senator Johnston.
Thank you, Mr. President. I ask to be listed as a co-sponsor of Senate Bill 135.
Senator Johnston will be listed as a co-sponsor of Senate Bill 135. Senator Scott.
Mr. President, thank you. I move the Senate resolve itself into the Committee of the Whole for consideration of general orders, second reading of bills, consent calendar.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The Senate will resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills, consent calendar. Senator Scott will take the chair.
The committee will come to order. The court rule is relaxed. Mr. Majors, or Mr. Majority Leader? No. Mr. Majors, would you please read the titles to all the bills on the general orders consent calendar, second reading of bills, consent calendar.
House Bill 1033 by Representatives Buchanan, Nordberg, and Senators Cafalas and Newell concerning the Colorado Human Trafficking Council. House Bill 1038 by Representatives Mountain and Salazar and Senator Jones concerning an optional affiliation with the Fire and Police Pension Association by a county sheriff department that does not participate in Social Security.
Majority Leader Scheffel.
Thank you, Mr. Chairman. I move that the committee adopt the bills listed on the general order second reading of bills consent calendar, which includes House Bill 1033 and House Bill 1038. Ask for an aye vote.
Is there any discussion? The motion before the body is the adoption of all the bills on the general orders consent calendar. All those in favor say aye. All those opposed, no. Seeing no conflicts, the bills are approved. Mr. Majority Leader.
Thank you, Mr. Chairman. I move the committee rise and report.
Oh, I'm sorry. The motion before the body is that the committee rise and report. All those in favor say aye. All those opposed say no. Seeing that the ayes have it, we will rise and report. Sorry. Forgot that little one.
Okay. The Senate will come back to order. Senator Scott.
Thank you, Mr. President. The committee has considered two bills. Mr. Major, would you please read the report?
March 8, 2016, Mr. President, the Committee of the Whole begs to report that under consideration the following touch bills being second reading thereof makes following recommendations thereon. House Bill 1033 and House Bill 1038 passed on second reading and ordered revised and placed on the counter for third reading and final passage.
Senator Scott.
Thank you, Mr. President. I move the adoption of the report.
Is there further discussion? Seeing none, the motion before the body is the adoption of the report of the Committee of the Whole. Are there any no votes? With 33 ayes, 0 no, 0 absent, 2 excused, the report of the Committee of the Whole is adopted. House Bill 1033, House Bill 1038 passed on second reading and ordered revised and placed on the calendar for third reading and final passage. General orders, second reading of bills. Senator Scott.
Thank you, Mr. President. I move the Senate resolve itself back into the Committee of the Whole for the consideration of general orders, second readings of bills calendar.
You've heard the motion. All those in favor say aye. Those opposed, no. The ayes have it. The Senate will resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills. Senator Scott will take the chair.
Thank you, sir. The committee will come to order, and the court rule is relaxed. Mr. Majors, would you... Oops, I'm sorry. Mr. Majors, would you please read excuse me. Where did I go? I lost myself. Mr. Majors, would you please read the bills on the general orders? Oh, I'm sorry. My apologies. You just want to go one by one? Got it. Mr. Majority Leader? No? Mr. Majors, please read the title of Senate Bill 116.
Senate Bill 116 by Senator Johnston concerning the creation of deceptive trade practice under the Colorado Consumer Protection Act for a private custodian of criminal justice records to fail to remove a sealed criminal justice record from the custodian's database after receiving notice of a court-ordered sealing that criminal justice record.
Mr. Majority Leader.
Thank you, Mr. Chairman. I move that the committee lay over Senate Bill 116 to the end of the general orders, second reading of bills calendar.
You've heard the motion. All those in favor say aye.
Aye.
Those opposed say no. The motion passes. Mr. Majors, please read the title of Senate Bill 123.
Senate Bill 123 by Senator Lundberg and Representative Singer concerning the free access for high occupancy vehicles to high occupancy vehicle and high occupancy toll lanes on state highways and in connection therewith prohibiting the Department of Transportation and the High Performance Transportation Enterprise from requiring a vehicle owner to use a switchable transponder or other device in order to travel in a high occupancy vehicle on such a lane without paying a toll.
Senator Lundberg. Oh, I'm sorry, Mr. Majority Leader.
Thank you, Mr. Chairman. I move the committee lay over Senate Bill 123 to March 11th.
You've heard the motion to lay over Senate Bill 123. All those in favor say aye. All those opposed, no. The ayes have it. Senate Bill 123 will be laid over. Mr. Majors, please read the title to Senate Bill 132.
Senate Bill 132 by Senator Cook and Representative Foote concerning clarifying that test results relating to certain DUI offenses are not public information.
Senator Cook.
Thank you, Mr. Chair. I move Senate Bill 132 and Judiciary Committee report.
Thank you, Senator Cook. Please proceed with the committee report.
Thank you, Mr. President. The committee report basically just changed a couple words from BAC and drug to breath alcohol.
Okay. Thank you, Senator Cook. Is there any discussion on the committee report? Seeing none, Senator Cook.
Thank you, Mr. Chair. Senate Bill 132 basically protects...
Senator Cook, excuse me, we have to adopt the committee report. All those in favor of approving the committee report say aye. Aye. All those opposed, no. The committee report is adopted. Sorry about that. Senator Cook, to the bill.
Thank you, Mr. Chair. Again, I move Senate Bill 132. It basically protects individual personal information. Let me explain what happens when somebody gets arrested for DUI and they take a blood test. The Department of Public Safety controls that information, and so individual personal information like name, date of birth, driver's license, etc., is not made public. It's not corable, and it's not subpoenaed on the whole database. If you take a breath test, that's controlled by CDPHE, and there's a database, and those names potentially can be made public for everybody. And let me explain a little bit about the breath test. The EBAT, as it's known, or the Evidential Breath Alcohol Testing Program, is a state-run program that calibrates and certifies all the intoxilizers, all the instruments used by law enforcement, and the program also houses data related to individual test results and devices. What it also does, when somebody gets arrested, they give out information to the defense attorney and to the client for that individual person. It gives out a readout of the intoxilizer. It has all the information in there. It talks about, was the person observed for 20 minutes? Did they regurgitate anything for 20 minutes? It talks about the air samples, et cetera, et cetera. They also give to the client and the attorney the certification of that particular machine. Third page, they give the performance report on how the validation is done on that particular machine. So it talks about error rates, if there's any error rates, if there's any invalid samples, range if it's exceeded in any particular way. Then it goes into the performance instrument specifically of that particular machine, all the testing and all the calibration throughout the entire time that machine has been operational. So they give more than what's required by statute. So despite providing such comprehensive information about the subject's breath alcohol tests and data about the actual instrument on which that person has been tested, the EBAT program receives numerous requests for individuals' subject breath alcohol records from the data in the department's database. The requests for individual breath alcohol test records that do not belong to the person facing action. So the data in the department database contain personal identifying and sensitive information and should be protected. CDPHE has spent considerable time with CORA and with being subpoenaed by defending this practice, and they've already spent $82,000 in court costs. So I think we need to protect these people, because what's going on is an individual is subpoenaing the entire database for people that aren't their clients. And I think we need to keep the names, dates of birth, driver's license, and information on these individuals not being corable or subpoenaed. And I do have an amendment.
We have an amendment on the desk. Thank you, Senator Cook. Mr. Majors, please read the amendment.
Amendment L003 to Senate Bill 132 by Senator Cook, amendment printed bill page 2, line 23. After containing, insert personal identifying information
Senator
relating
Cook.
to...
Thank you, Mr. Chair. The amendment...
Would you like to move the amendment,
I'm sorry.
Senator Cook?
Thank you, Mr. Chair. I move L003.
L003 is properly moved. Senator Cook.
Thank you, Mr. Chair. The amendment on page 2, it talks about that the database compiled by the Department of Public Health and Environment, the personal identifying information relating to the breath test is not public information, but it does go on to say that the person's breath test, alcohol, and all personal information that are not public, the Department of Public Safety and Environment shall disclose such only information to the attorney, the client, and to law enforcement. The amendment also states that any may release non-personal identifying information from the database, just not the personal identification. So basically what the amendment does, it narrows the focus of the bill to protect personal information. It ensures that the district attorney and other authorized officials have access to the data, and it specifically states that the data not containing personal identifiable information is still subject to CORA. This includes data that should be specific to an officer under scrutiny from defense counsel, as well as aggregate data on technology and a pass-fail rate.
Oh, yeah. Senator Merrifield.
Thank you, Mr. Chair. I just wanted to thank the good senator from north of here for working with us on this amendment. We consider it a very friendly amendment, and with that amendment would support the bill. Thank you.
Is there any further discussion on L003? Seeing none, the question before the body is the adoption of L003. All those in favor say aye. Aye. All those opposed, no. The ayes have it. L003 is adopted. Senator Cook, to the bill.
Thank you, Mr. Chair. I move 132 again and ask for an aye vote.
The motion before, is there any further discussion on Senate Bill 132? Seeing none, the motion before the body is the adoption of Senate Bill 132 as adopted, as amended by L003. All those in favor say aye. Aye. All those opposed, no. The ayes have it. Senate Bill 132 is passed. Mr. Majors, would you please read the title to House Bill 1284?
House Bill 1284 by Representatives Nordberg and Moreno, Senators Hill and Garcia, concerning divestment by the Public Employees Retirement Association from companies that have economic prohibitions against the State of Israel.
Senator Hill.
Thank you, Mr. Chair and colleagues. We've got a House bill over here that many of you I know have heard of. It highlights in many ways what we share in relation as Colorado to our friend in the Middle East. We've got a lot of energy, a lot of innovation, a lot of excitement about the future that Colorado represents, and we share that friendship. But more deeply, there's a movement right now.
Senator Hill, would you please move the bill? Sorry.
Thank you, Mr. Chair. I move House Bill 1284.
Thank you. Please, and the committee report.
And the Finance Committee report.
Thank you, Senator Hill. To the committee report first, please.
Thank you, Mr. Chair. Colleagues, for the committee report, we just added 2 lines to clarify that we're including the boycott of divestment from or imposition of sanctions on the State of Israel.
Thank you, Senator Hill. The question before us is the adoption of the committee report. All those in favor say aye. Aye. All those opposed, no. The committee report is adopted. To the bill, Senator Hill. Thank you.
Thank you for your patience, Mr. Chair and colleagues. House Bill 1284 recognizes that there's a movement afoot to colleagues to bring foreign policy into economic activity of what's going on here in the United States. And what we're saying is this brings an unfair risk into some of our investments, and we're directing PARA in this bill to keep a list of those companies that are participating in the act of boycott, divestment from, or sanction of Israel, and saying this risk is unacceptable to the portfolio of investments that we keep to manage retirements for Colorado's public employees. That unacceptable risk into the portfolio is justification for us to come and say PARA shall not invest in those companies actively participating in the boycott, divestment, or sanction of Israel.
Is there any further discussion on House Bill 1284? Senator Newell.
Thank you, Mr. Chair. I just wanted to rise in opposition to House Bill 1284, and I will do so civilly, but I wanted to make sure that people knew why I was voting against this bill. I very much respect the sponsors. However, I just believe this is not appropriate for state policy. As people know in this chamber, I have stood for peace almost my entire life. And by passing this bill, PARA would be forced into extra work and costs on their end, and to take a stance on a foreign policy issue which has no effect on them. The board of PARA is opposed to these terms. The bill offers no benefits to Colorado constituents, and many are opposed to it. Boycott, Divestment, and Sanctions, BDS, is a non-violent movement that seeks equal rights by encouraging Israel to end its occupation of Palestinian land, recognize the rights of Arab Palestinian citizens of Israel to full equality, and respect the rights of Palestinian refugees. It is a grassroots movement for freedom, justice, and equality inspired by Gandhi, U.S. civil rights, and South African anti-apartheid movements. It's founded on anti-racist platform that rejects all forms of racism, including Islamophobia and anti-Semitism. The Nobel Peace Prize winner, whom I've met, Archbishop Desmond Tutu, supports the BDS movement. In South Africa, he says, "We could not have achieved our democracy without the help of people around the world who, through the use of nonviolent means, such as boycotts and divestment, encouraged their governments and other corporate actors to reverse decades-long support for the apartheid regime. The same issues of inequality and injustice today motivate the divestment movement, trying to end Israel's decades-long occupation of Palestinian territory and the unfair and prejudicial treatment of the Palestinian people by the Israeli government ruled over them. Every Republican and Democratic president since 1967 has opposed Israeli settlements on Palestinian lands. The people who are opposed are ACLU, Coloradans for Justice in Palestine, Friends of Sabeel, Colorado, Front Range Jewish Voice for Peace, American Friends Service Committee, Colorado office, the Green Party of Colorado, Boulder Branch, Women's International League for Peace and Freedom. And I do too. This is, I believe, inappropriate and doesn't have benefit. Please let's stop the separation and unify people in peace. This bill does nothing to do that. We need now more than ever to model civility, respect, and equality. This is not only unnecessary, it's a deliberate poke in the eye to those trying to get to peace. I ask for a no vote on 1284.
Is there any further discussion on House Bill 1284? Senator Kafals.
Thank you, Mr. Chair, and good morning, colleagues. I rise in respectful opposition to House Bill 1284, primarily for three reasons. One is that all of the communications that I've received from my constituents in Fort Collins, the city that I represent, have been opposed to this bill, have expressed opposition to this bill. A second reason is that PARA, as I understand it, continues to oppose this bill. And a third reason, perhaps I would say the most important reason, is that I am not convinced that this is a proper course of action. And I base that on an experience that I had in traveling to Israel and Palestine in 2002 as part of a Mideast citizen diplomacy delegation. The leader of our delegation was a woman rabbi, and the delegation was comprised of Jewish people, Christian people, and Muslim people. In that experience, I learned that all sides in this conflict have suffered immensely. We spoke to many, many different people. We spoke to mothers who lost children as a result of suicide bombings on buses when those were occurring 10 and 15 years ago. We talked to Palestinians whose homes had been bulldozed. We traveled to kibbutzes. We visited Jerusalem. We were in the West Bank. We were in the Gaza Strip. We were in Palestinian villages in Israel proper. And I think that one thing I learned from that experience, among others, is that the people themselves really want to achieve a lasting peace in that part of the world. That, as is often the case, governments are the ones that complicate things, and the people want a lasting peace. And because of that experience and the other reasons that I've stated, I am compelled to rise in respectful opposition to this bill. Thank you.
Senator Crowder.
Thank you, Mr. Chair, and I rise in strong support of this bill. 1284 gives us an opportunity to create some of that peace that is spoken in this room. I've traveled throughout the Middle East, and I'm sure a lot of you have, and we've learned what the situation, what the problems are there. And anytime that you embolden or you financially empower the enemies of Israel, it creates a situation of more contention. The reality is what we have here is a situation where, one of the first words was there's a movement abreast. There is a movement abreast, and they are our ally. And if we are going to support our allies, this is one very, very positive way and very peaceful way in which to do it. Because the countries that do not recognize Israel, if they would like the investment of the PARA money or the money from the United States, all they have to do is recognize Israel, and that's how simple it is. What better distinction on creating a peaceful solution to the entire Middle East than to acknowledge Israel? So I'm very supportive of this, and there's and I will be a very positive yes, but I think the effects of this are long stretching, and I think what it does is tell the people that, Israel is our ally, and what we want in that region is peace. And I think if, and I would encourage other people to visit this region and see for themselves. Thank you very much, Mr. Chair.
Senator Heath.
Thank you, Mr. Chair. This is a matter that has caused me a great deal of consternation. Obviously, has made me do a lot of thinking, and that's always one of the things I think we all get out of being down here, that it really makes us think about what we stand for, what our values are, and where we're coming from. I've probably, this session, gotten more emails on this particular bill than any one that I've received this time from my constituents, and they have been overwhelmingly asking me to oppose this bill for a myriad of reasons, some of which deal with the conflict that the bill talks about. In fact, most of them deal with that, but I don't want to talk about that so much today. This body has spent a lot of time during my 8 years talking about PARA. In fact, we passed Senate Bill 1 back in one of my original years, I think the second year I was here, because PARA was in difficulty because of the recession that we were under. All of our investments were in trouble, and we spent a lot of time making certain about how we made certain that that PARA continued to do what it was set up to do, and that was to ensure the retirement of our employees. And we took some very, very difficult steps at that time with PARA to include increasing employees' contributions, I actually attended several meetings that were being held all around the state with para employees at that time, and we took some very, very difficult steps. And I'm very glad that we did, because we have restored para to a place that I think we can be relatively comfortable with, although we obviously continue to need to monitor it. So forgetting all of the issues around conflict, just looking at this bill as it deals with para, I think it is absolutely the wrong thing to do. We have established within para a board that basically is there to make sure that para stays firm and stable and fiscally solvent. To begin to put these kinds of restrictions on the investment policy of para, I think, is totally wrong. I think the precedents that this would establish is something that I can't live with, and I hope you can't live with either. Because any time any major conflict happens anywhere in the world, if we adopt this policy, we should be then asking para to do the same thing with regard to that conflict. That is not what we should be doing with an institution that has been established to protect the assets of all of our employees that fall under para. So without regard to the conflict issues that this deals with, I would ask you, just from a fiscal point of view, that this is not the right thing to do. To involve para in this is not the right thing to do. I would, for that reason, ask you to vote no on this, because I believe it establishes a precedent that we should not be doing. Thank you.
Senator Lundberg.
Thank you, Mr. Chair. I think it is appropriate to come down and address the question of is it appropriate for the legislature to step in from time to time and give some direction to para or not. I quite agree with the previous speaker that it's something we shouldn't do every time, very much so. And when I saw this bill come through, I asked myself, so is this the time or not? Because it's not without precedence. Understand that. And it's been a while. Let's see, this is my 8th year in the Senate, and I remember I was on the Finance Committee in the House when this was last considered in directing para on how to engage in investments concerning an international issue. And we did take action, and it was appropriate. So it's not without precedent. I believe it should be rare, but there is a time and there is a place. And when it comes to this bill before us today, I am supporting it because I believe this is an appropriate, really two things. One, it is appropriate to step in and engage in this discussion at this level. But number two, it's appropriate to direct para to stay out of this conflict of discussion, really, because this bill is saying do not invest in those businesses that are engaging in this, this boycott. I believe it's appropriate. And as I say, it's not without precedent. It should be rare, but it should not, it is also well within the purview of the legislature to ensure that the retirement investments are handled properly and safely.
Senator Crowder.
Thank you, Mr. Chair. I'll be very brief. Government sanctions have been in place since we've become a country. There's an aspect of this bill that indicates if the federal government goes against this, then it will go nowhere. But the reality is, we should not be financing any entity against our ally that could actually become a situation where it creates a harmful atmosphere for the soldiers that we have there in the region. So I stand by my statement. I do not believe that empowering the enemies of Israel is to the best interest of the state of Colorado or this country, but primarily for the reason that our veterans ultimately get wound up in this or get caught up in this, and I do not believe that anybody should be making money to the point where they would use that against the military of this country. So therefore, I will stand for this bill. Thank you.
Senator Holbert.
Thank you, Mr. Chair. Members, I rise in support of House Bill 1284 and grateful to the sponsor for bringing the bill. I'm not an expert, but I've been there. I've seen it. For those who want to boycott, divest, or sanction Israel for whatever reason, I disagree, but I have to respect that some may have that view. But I think it's very important that we recognize and understand that the BDS movement hurts people in the West Bank, that the BDS movement hurts Palestinians and Jews who live in the West Bank. There is one democratic force, entity in that part of the world. There's one nation, one country, one state that allows, say, women to vote, respects diversity, and that's Israel. But if someone wants to be opposed to what the nation of Israel stands for, that's your choice. But let's be clear that the BDS movement takes opportunity away from people in Palestine, in the West Bank. To push companies out of that area that provide jobs and opportunity hurts the people there in that very desperate place. So causing sanction, divestment, boycott against Israel might be the motivation, but the end result is that the people who you might be trying to help are probably hurt the most. I appreciate the sentiment here, and I was most impressed by a presentation that a group of us heard from a Palestinian, and I will not do his name justice, but Ali Abu Awad, and Rabbi Hanan Schlesinger, who live in the West Bank, and have come together with a simplest of agreements of a basis for understanding. They have agreed not to kill each other, because that is a harsh reality where they live, that people do kill each other. But Ali and the rabbi have come together to try to find some common ground, some agreement on how that they move together, whether that's a one-state or a two-state solution, I don't know. But I was so impressed with these two men who have just come together as neighbors and said, let's try to find a way. I think the BDS movement works against those efforts. I think the BDS movement works against prosperity and opportunity for that most conflicted and challenging place. And I would ask you to please support 1284, because I think it does the right thing for the state of Colorado, for Para, that we will not be involved in that and not cause further pain for people who need our help the very most. I ask for an aye vote on 1284.
Senator Johnston.
Thank you, Mr. Chair. I just want to say a couple of words about why I support House Bill 1284, and a little bit what I think House Bill 1284 does not do. I think House Bill 1284 is not an affirmation of the current policies of the Israeli government in the West Bank. House Bill 1284 does not say whether you do or don't agree with the current settlement policy, or whether you do or don't agree with the right to return, or whether you do or don't agree with the Green Line as the national border, or whether you do or don't agree as a two-state solution. House Bill 1284 asks a different question, which is, do you believe that you ought to use the Treasury of the state of Colorado to sanction an ally? That is the question. And the question there is, how do we treat with other allies with whom we may have disagreements? Because we do have other allies with whom we have disagreements, right? If you look at Turkey as an example, right? Turkey is an international ally. Turkey has also made some regrettable steps towards reducing civil liberties in their country, even to the extent of killing 50 peaceful civilians who gathered to rally for those civil rights. We are not currently sanctioning Turkey. The federal government is not doing it, no state government is doing it, because they are an ally with which you engage in conversation about disagreements. Same with the nation of China. Right? There are many of us who have concerns about the nation of China's handling of their religious Falun Gong movement and their failure to adequately respect their rights and the loss of up to 65,000 lives of the Falun Gong members. There is not currently federal or state boycotts against the country of China, in the same way that there's not against the Czech Republic because I disagree with their refusal to accept Syrian refugees. The precedent is when you have relationships with allies, what you do is you engage in conversation about what those disagreements mean. And that you don't instead resort to state sanctions as the strategy to engage in those negotiations. And you certainly don't engage in state-level sanctions of those entities. And so if you believe that you don't want to use the Treasury of the state of Colorado to sanction an ally, I would ask you to vote for this bill. And I would say there is adequate precedent to say it doesn't mean that allies always have to be right or that we always have to agree. It actually means, consistent with the resolution brought this morning, that we agree to keep talking. And that talking and that engagement is what solves problems with allies. I'd ask for an aye vote.
Seeing no further, I see one more. Senator Aguilar.
Thank you, Mr. Chair. And like so many of my colleagues, I always hate rising after that senator from Denver because he is very eloquent. And I think I was compelled to rise by a statement from another senator from southeastern Colorado. And I do agree that Israel is our ally and that we want peace. He had encouraged that we visit the Middle East to get some understanding. And like many of you in this audience, I've had the privilege of visiting the Middle East. I was in Syria in 2010 before the Arab Spring, and I was in Palestine, and I was frankly embarrassed about the way the people in Palestine were being treated, and regardless of that foreign policy and Israel being our ally, I guess I feel like as a state senator that it's not my role to engage in that disagreement. And in fact, the senator from Denver mentioned Turkey. I don't know if any of you know, but the president of Turkey took over the free press on Friday, and that has appalled me. And I've written a letter to our congresspeople in Washington expressing my concern and asking them to take action. Because in my opinion, as a state senator, my role is to rely on my congressional delegation to take action on foreign issues. So that, combined with PARA's opposition to this bill, leads me to be a respectful no today.
Senator Garcia.
Thank you, Mr. Chair, and I rise in full support of House Bill 1284 and want to address maybe the implication that this is harmful for PARA by stating that I think this is the exact opposite, that this is strengthful for PARA, and want to address the concerns of whether or not this is against the peaceful movement, and believe that efforts that help create the BDS movement help to delegitimize Israel's right to exist as a Jewish and democratic multicultural state, and those efforts are concerning. And that peace doesn't come from that side of outside pressure that the BDS movement will pursue. It just hampers and hardens both sides. I would argue that if you're pro-progress, that you should be anti-BDS. And while Israel was created in 1948 out of the ashes of the Holocaust because of a need to exist and be safe, a safe haven for Jews, today, in 2016, Israel is able to thrive because it is proven to add value. Its existence contributes to the world. I mean, Israel is broadly recognized as a 21st century innovator in medicine and agriculture, water, technology. The world simply is better off with Israel in it. And I would argue that efforts through BDS that seek to undermine and harm the existence of Israel and create economic warfare in that part of the region and those types of tactics are unacceptable, especially for one of America's strongest allies. I would urge an aye vote on House Bill 1284.
Seeing no further discussion on House Bill 1284, Senator Lundberg. Lambert, I'm sorry.
Thank you, Mr. Chair. Having lived in the Middle East for 3 years and being very close to about 3.5 million of my closest Palestinian friends in Jordan, I'm fairly close to this issue. My concern is how sanctions are being used against Israel to raise expectations of coming conflict. We talked a lot this morning about conflict resolution. Boycotting Israel economically is an act of war. It is not conflict resolution. We need to step back and think about this. The Assistant Majority Leader mentioned experience he had in House Finance. I was there in House Finance as well when our former Speaker of the House, Romanoff, brought forth a sanctions bill involving PARA to divest PARA from the genocide going on in Somalia. And I think he was generally, for some reason, surprised that I voted for that sanction. Genocide is what we're talking about here, folks. We run resolutions every year about the Holocaust. We run resolutions every year about the Armenian genocide. This continues into the 21st century in Israel. It is hate. It is death. It doesn't involve just one country. It involves an attitude that we see spread across the front pages of our newspapers every day. When is this going to stop? And we are concerned about economic development for our retirement system. History is working against us. We iconize the Nazis of World War II for their extreme hatred, their extreme genocide against the Jews, and yet at that time there were American companies doing normal day-to-day business with Nazi Germany. And Americans took sides with that. We had some that supported that trade. We had some Americans that supported Nazi Germany until we actually went to war. And we look back, and I think some of my colleagues have asked the question, how could this have happened? And I think we need to look back at history and examine how it did happen, because the economics were more important than the morality of the situation. This is a moral question. And I think I would encourage you all to think about that and vote in favor of this bill.
Seeing no further discussion on House Bill 1284, the question before the body is the adoption of House Bill 1284. All those in favor say aye. Aye. All those opposed say no. The ayes have it. House Bill 1284 is adopted. Mr. Majors, please read the title to Senate Bill 58.
Senate Bill 58 by Senator Hill and Representative Becker K. concerning the regulation of certain foods in connection therewith exempting certain food producers from licensure, inspection, and other regulation.
Senator Hill.
Thank you, Mr. Chair. I move Senate Bill 58 and the Business, Labor, and Technology and Appropriations reports.
Thank you, Senator Hill. To the Business and Labor Technology report.
Thank you, Mr. Chair. Colleagues, the BLT report is actually the essence of the bill. We started down a path with the introduction, where they introduced bill and then worked with a whole group of stakeholders, including Department of Public Health and Agriculture, to bring this to a point that they could, if not support, at least be neutral on. The Business, Labor, and Technology report basically is a strike below amendment and a couple other amendments that we did that address two issues. One is opening up the cottage foods industry rather than us saying what they can do. We're just making a simple list of what they can't do, and then moving on and freeing up poultry production here in Colorado to get closer to permission the federal government gives us on poultry production.
Senator Holbert.
Thank you, Mr. Chairman. Rise in support of the committee report from Business, Labor, Technology and appreciate the sponsors' time and effort prior to that committee hearing, but even during. Also want to thank the members of Business, Labor, and Technology for their endurance and patience during that committee. Really, a lot of work went into this, this committee report. This amendment asks for an aye vote.
The question before the body is the adoption of the committee report to Senate Bill 58. All those in favor say aye. All those opposed say no. The ayes have it. The committee report is adopted to the bill. Senator Hill.
Thank you, Mr. Chair. I just, on the appropriations report, we just added the appropriations clause.
Thank you, Senator Hill. Did you move the appropriations report?
I did, yes, sir. I move Senate Bill 58 along with the appropriations clause, appropriations report.
Thank you, Senator Hill. To the Appropriations Committee report.
Again, Mr. Chair and colleagues, the appropriations report we just added the appropriations clause.
The question before the body is the adoption of the Appropriations Committee report to Senate Bill 58. All those in favor say aye. All those opposed say no. The ayes have it. The Appropriations Committee report is adopted. Senator Hill, to the bill.
Thank you, Mr. Chair. Colleagues, again, as I mentioned, the BLT report was really the essence of this bill. We do have potentially a couple more changes, minor changes that we need, and we're looking to do that in the House, I will mention. But we still have some more work to do to free up Colorado's businesses. The idea here is that we started a cottage foods industry in Colorado, and we limited what they could sell. And last year, we spent a lot of time on coming up with Tier 2, and that's been difficult to implement. So we worked with a group of stakeholders to say that here in Colorado, businesses, farms can sell directly to the end consumer, not retail sales, but end consumer, basically anything that doesn't require refrigeration. That's what this bill does. Rather than us telling them what they're allowed to, we're opening this up a bit and saying you're just allowed to sell anything that's produced here in Colorado, whether it's salsas, whether it's pickles, whether it's baked goods or jams or jellies. You can sell those directly to the end consumer without needing government permission or special inspections to do that. I think it's one of the aspects of Colorado here that we all appreciate, and this moves us down the road a little bit. You've heard certainly some different rumors about this bill. I started this as a statement bill, and it came out to be something that we really could make Colorado's consumers better off. We added a few amendments in committee. And one of those was an amendment to say we recognize we'd like to eventually be able to sell both poultry produced here in Colorado for retail sales, and yet we don't have the insurance. We don't have the insurance or the regulations in place to be able to do that well and do that safely. So we've directed Department of Agriculture to have a stakeholders meeting on what we can do, and Public Health as well, on what we can do to provide retail sales for poultry produced here in Colorado. With that came a new fiscal note. I do have that here, a state revenue impact of $300 and state expenditure impact of $3,800. So basically no fiscal impact on this bill. Ask for your support on making it easier to sell Colorado products here within Colorado.
Seeing no further discussion, the question before this body is the adoption of Senate Bill 58. All in favor say aye. All those opposed, no. The ayes have it. Senate Bill 58 is adopted. Mr. Majors, please read the title to Senate Bill 62.
Senate Bill 62 by Senator Marble and Representatives Becker, Jay, and Vio concerning modifications to the regulation of veterinary pharmaceuticals.
Mr. Majority Leader.
Thank you, Mr. Chairman. I move the committee lay over Senate Bill 62 to March 9th.
The question before the body is the layover Senate Bill 62. All of those in favor say aye. All those opposed, no. The ayes have it. Senate Bill 62 will be laid over till tomorrow. Mr. Majors, would you please read the title to Senate Bill 102?
Senate Bill 102 by Senator Kerr concerning the elimination of mandatory sentences to incarcerate
Senator Kerr.
certain crimes.
Thank you, Mr. Chair. I move Senate Bill 102 and the Appropriations Committee report.
To the committee report, Senator Kerr.
Thank you very much, Mr. Chair. The Appropriations Committee report kind of spells out the savings that will be realized with this bill. I ask for an aye vote on the Appropriations Committee report.
The question before the body is the adoption of the Appropriations Committee report to Senate Bill 102. All those in favor say aye. All those opposed say no. The ayes have it. The Appropriations Committee report is adopted. Senator Kerr, to the committee report. Did you have a? I'm sorry. To the bill, Senator Kerr.
Thank you very much, Mr.
And I think you need to move the bill. I'm not sure. Let's do it twice just to be solid.
I move Senate Bill 102.
Thank you, Senator Kerr. Please continue.
Thank you very much. Senate Bill 102 helps reduce some of the mandatory minimums that have been in place in Colorado statute over the last few years. It does not take a broad swipe at these. It is actually very targeted at some second-degree assaults and also bail bond convictions. And with that, we also have an amendment that I'd like to bring forward.
Thank you, Senator Kerr. There is an amendment on the desk. Mr. Majors, would you please read Amendment L002?
Amendment L002, Senate Bill 102 by Senator Kerr, amendment print bill, page 2, line 21, strike, repeal, and substitute.
Senator Kerr.
Thank you very much, Mr. Chair. I move L002. L002 goes to the bail bond portion of the bill, and the domestic violence groups, the groups that work against domestic violence, came to us with a concern that they thought if we took these particular offenses out, both among for domestic violence offenses and also witness tampering, that would weaken some of the provisions the DAs have when dealing with these particular offenses. So we worked with the domestic violence advocates to include these two areas to keep in with the mandatory minimums on the bail bonds, but to still exclude the rest of them.
Is there any further discussion on Amendment L002? Seeing none, the question before the body is the adoption of L002. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it. L002 is adopted. Senator, no, I'm just kidding. Senator Lundberg.
Thank you, Mr. Chair. Members, just come down to the microphone for a moment to state that I support this bill. I'm on a co-sponsor. I think it does the appropriate, it does take the appropriate steps in a limited number of cases to give the court the prerogative to determine what the sentence should be, rather than being locked into you have to be there. And I hope the sponsor will take a little more time to describe some of the particulars. But in my judgment, it is appropriate. I don't vote for every elimination of mandatory sentencing, but when I looked at what this particular bill is covering, I did see it to be the appropriate line to draw for what truly is closer to the best judgment for the best justice in the penalty for these crimes. So with that, just wanted to pass that on as far as why I was voting the way I'm voting.
Senator Kerr. Seeing no further discussion, Senator Marble.
Thank you, Mr. Chair. I rise in support of Senate Bill 102. After working in the bail bond industry for almost 20 years, I know this to be a good bill. And I also know that out of the hundreds, thousands of people that I dealt with, no blanket policy should be adopted for a failure to appear. Every case should be applied differently. there were people in the hospital. There were people who had very good reasons for failing to appear, and justifiable. But when you look at what this sentence imposes upon them, that was not justice. So I really am very, very supportive of Senate Bill 102, and I really, really enjoy being on the line of people on this in support of something that we all come together on and understand that, yes, there is a problem here. And for the good senator to bring it to light, I just want to applaud his efforts and say thanks.
Senator Crowder.
Thank you, Mr. Chair. I'd like to ask the sponsor, basically the way I look at this is whether a judge would have the discretion or make it mandatory for second-degree assault. If that is correct, could you give me an example of a second-degree assault? Could you define what exactly that means with an example?
Senator Kerr.
Thank you, Mr. Chair, and thank you for the question. Yes, so I want to be clear here that this bill does not look to minimize the seriousness of offenses that come in with assault in the second degree. The second-degree assault will still be considered a crime of violence and will be subject to a sentence to prison in the aggravated range of 5 years in prison up to 16 years. Just gives the discretion to the judge. As far as examples go, there are some good examples given in the Judiciary Committee where we heard this. And one of the more common ones is if you're a person might be in a public place where certain adult beverages are served and a conflict breaks out, and unfortunately a certain senator from Littleton is not there to help us come to a nonviolent resolution of this particular conflict. And so punches are thrown, there's an aggressor in the fight, and somebody who is there doesn't want to be involved in the conflict but is protecting themselves and throws a punch and breaks the aggressor's nose. Now, under current statute, the person defending themselves, throwing that punch to defend themselves, but breaks the aggressor's nose, they can and have been charged with second-degree assault in cases like this. And so the problem lies in the fact is that if that charge is being brought and that person feels like they have a good case, I was defending myself, but yet the charge is still coming forward, I think most of us would say, well, we'll take that to trial, and I'm sure the jury will rule in our favor. The problem is that with a 5-year mandatory minimum on this, if for whatever reason the jury decides against you, you are going to prison for 5 years because you happen to be in the wrong place at the wrong time trying to defend yourself, and somebody brought this charge forward. So this is the case where a judge then would have the discretion to look at that and say, you defend yourself, you go to trial, the jury still finds against you, but the judge sees that you were truly trying to defend yourself. You are not subject to a 5-year mandatory sentence at that point.
Thank you, Senator Kerr, for that incredibly long response. Senator Cook.
Thank you, Mr. Chair. I opposed this bill in committee, and I rise in opposition to it now. The good senator from Lakewood talked about when he came down and started speaking about the bill. He said, we are nibbling away at mandatory minimums. And that was one of my issues with it, by nibbling away. There seems to be a movement to let's do away with mandatory or consecutive sentences one bite at a time. Let's nibble at it one bite at a time. Now, I'm not saying every judicial bill needs to go through CCJJ, but if we're going to make a policy decision as big as sentencing reform, let's have an honest debate, an honest dialogue in CCJJ. And let's talk about it there and bring it to the Senate. That didn't happen. Instead, we want to nibble away piece by piece. Second-degree assault is also more than just punching a guy in the nose. Serious bodily injury. You have to have serious bodily injury. You also can use a weapon and be charged with second-degree assault. We heard a lot about the people not trusting the juries. Oh, so we're going to go to a mandatory plea bargains. So somebody gets charged with second-degree assault, they get charged with a felony. They don't want to take that risk of going to prison, so they're going to plead guilty to something else. So we heard a lot about the juries and how much people don't trust juries. But that is one of our most sacred rights in our Bill of Rights. It's a jury system. It's a jury of your peers who are deciding whether or not you should be charged or guilty of second-degree assault by punching somebody in the nose. I say this is a bad bill, and let's have an honest, open discussion at CCJJ and bring it back if we want to do a real sentencing reform.
Seeing no further discussion on Senate Bill 102, the question before the body is the adoption of Senate Bill 102. All those in favor say aye. Aye. All those opposed say no. The ayes have it. Senate Bill 102 is adopted. Mr. Majors, please read the title of Senate Bill 115.
Senate Bill 115 by Senator Martinez-Dominic, concerning electronic filing system for documents recorded with the county clerk and recorder in connection therewith creating an electronic recording technology board, which is an enterprise authorizing the board to set an additional filing surcharge for a 5-year period, requiring counties to transmit the proceeds of the board's surcharge to the state for deposit in cash fund administered by the board, requiring the board to make grants from the fund to counties to create, maintain, improve, or replace electronic filing systems, establishing reporting requirements for the board, and increasing a local filing surcharge.
Mr. Majors, would you please repeat that? Mr. Majority Leader.
Thank you, Mr. Chairman. I move the committee lay over Senate Bill 115 to March 9th.
The question before the body is the layover of Senate Bill 115 till March 9th. All those in favor say aye. All those opposed say no. The ayes have it. Senate Bill 115 is laid over till, I believe, March 9th. Is that correct? Done. I don't know how to. Mr. Majors, would you please read the title to Senate Bill 116?
Senate Bill 116 by Senator Johnston, concerning the creation of deceptive trade practice under the Colorado Consumer Protection Act for a private custodian of criminal justice records to fail to remove a sealed criminal justice record from
Senator
the
Johnston.
database after receiving notice of a court order sealing that criminal justice record.
Thank you, Mr. Chair. I move Senate Bill 116, and I move the Judiciary Committee report.
To the committee report, Senator Johnston.
Thank you, Mr. Chair. The committee report just clarified the focus on the sealing of records that are immediately eligible for sealing and the process to do that. Ask for an aye vote.
The question before the body is the adoption of the committee report for Senate Bill 116. All those in favor say aye. All those opposed say no. The ayes have it. Senate Bill, or the committee report to Senate Bill 116 is adopted. Senator Johnston, to the bill, please.
Thank you, Mr. Chair. I move Senate Bill 116, and I do have a quick amendment I want to move.
Senator Johnston?
Oh, I was going to speak to the amendment.
Okay, we have an amendment on the desk. Mr. Majors, please read the amendment L003.
Amendment L003 to Senate Bill 116 by
Senator Johnston.
Thank you, Mr. Chair. Quite simply, what this bill does is, right now under the current process, folks, if you are charged with a crime and you go and you are either acquitted of that crime or it is dismissed or you get a deferred judgment, under current law, in order to fix that problem, you actually have to file a civil lawsuit against the state to get your record sealed. This eliminates that and just creates the easy button by which you can immediately have those records sealed and have the courts do it for you rather than having to manage the really Byzantine process to do that. So this is similar to what we did in the committee report. It just clarified that this does not apply to any misdemeanor for which you would have to have a subsequent path of good behavior. So if you actually get convicted, you have to wait 2 or 3 or 5 years to get it sealed. This is simply making it eligible for those restricted set of charges that have been acquitted or dismissed or deferred judgments. So I'd ask for an aye vote.
take a senatorial 5. Senate will come back to order. Mr. Majority Leader.
Thank you, Mr. Chairman. I move the committee lay over Senate Bill 116 to March 9th.
The question before the body is laying over Senate Bill 116 till March 9th. All those in favor say aye. All those opposed, no. The ayes have it. Senate Bill 116 is laid over till March 9th. So we have nothing else, correct? Oh, I'm sorry. How you doing, Senator Sheffield? Nice to see you. Mr. Majority Leader.
Thank you, Mr. Chairman. I move the committee rise and report.
The question before the body is to rise and report. All those in favor say aye. Aye. Those opposed, no. The committee will rise and report. Thank you, Senator Sheffield. This is the same. No, we did that. Oh, here we go. I think so.
The Senate will come back to order. Senator Scott.
Thank you, Mr. President. The committee has met and had a number of bills under consideration. Mr. Majors, would you please read the report?
March 8, 2016, Mr. President, committee whole basic reports under consideration of the following tax bills being seconded. The makes following recommendations thereon. Senate Bill 132 is amended. Senate Bill 58 is amended. Senate Bill 102 is amended. Passed on second reading in order to gross place on the counter for third reading and final passage. House Bill 1284 is amended. Passed on second reading in order to revise and place on the counter for third reading and final passage. Senate Bill 62, Senate Bill 115, and Senate Bill 116 is amended, laid over until March 9, 2016, retaining their place on the calendar. Senate Bill 123 laid over until March 11, 2016, retaining its place on the calendar.
Senator Scott.
Thank you, Mr. President. I move for the adoption of the report.
You've heard the motion. Is there further discussion? Seeing none, are there any no votes? With 33 ayes, 0 no, 0 absent, 2 excused, the report of the Committee of the Whole is adopted. Senate Bill 132 as amended, Senate Bill 58 as amended, Senate Bill 102 as amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. House Bill 1284 as amended, passed on second reading and ordered revised and placed on the calendar for third reading and final passage. Senate Bill 62, Senate Bill 115, Senate Bill 116 as amended, laid over until March 9th and retaining their place on the calendar. Senate Bill 123 laid over until March 11th and retaining its place on the calendar. Consideration of resolutions. Majority Leader Shuffle.
Thank you, Mr. President. I move that the Senate lay over these consideration of resolutions calendar, which has 2 remaining resolutions on it, Senate Joint Resolution 11, Senate Joint Resolution 14, lay over to March 9th.
You have heard the motion. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. The Senate Joint Resolutions calendar will lay over until March 9th. Message from the House.
March 8, 2016, Mr. President, the House has passed on third reading and transmitted the revised statute, House Bills 1035, 1183, 1060, 1184, 1269, and 1215. The House has passed on third reading and transmitted the revised statute, House Bill 1255 is amended, House Bill 1272 is amended, House Bill 1070 is amended, House Bill 1103 is amended, House Bill 1141 is amended, House Bill 1229 is amended, House Bill 1270 is amended. The House has passed on third reading and returns here with Senate Bills 63, 55, 89, 90, 91, 92, 93, and 95. The House has adopted and returns here with Senate Joint Resolution 13.
Message from the Reviser.
March 8, 2016, we hear the transmitted without comment, House Bills 1035, 1060, 1183, 1184, 1215, and 1269. Without comment as amended, House Bills 1070, 1103, 1141, 1229, 1255, 1270, and 1272.
Announcements. Senator Woods.
Thank you, Mr. President. I ask for a moment of personal privilege.
Granted.
Thank you, Mr. President. Colleagues, 28 years ago today, my husband and I welcomed our second son into the world, so happy birthday, Michael. And then 2 years ago today, we welcomed our second grandson into the world, so happy birthday, Jace.
Senator Kafalis.
Thank you, Mr. President. Colleagues, just a reminder that today is International Women's Day, and therefore I think it behooves us to go out of our way even more to honor, respect the many contributions that women in the great state of Colorado have made in this country as well and in the world, to honor the women as part of International Women's Day. Thank you.
Further announcements. Mr. Majority Leader.
Thank you, Mr. President. Members, just a reminder as you begin to plan for the remainder of the month that the Senate will be closed. Senate will be closed on Good Friday, which is scheduled for March 25th of this month. Please take a note. March 25th, Good Friday, Senate will be closed. With that, Mr. President, move the Senate adjourn to 9 a.m. Wednesday, March 9th.
You've heard the motion. All those in favor say aye. Aye. Those opposed, no. The ayes have it. The Senate will be adjourned until 9 a.m. Wednesday, March 9th.